a few moments after we go through some of our ordinary business, but this will be our last GBM of the semester. So I hope you came prepared with some great questions. And with that, we'll get started. So let's meet the executive board. You should know us by now. My name is Jordan Blum, as I mentioned. My email is listed below. If you need anything for any reason, whether it's related to LSAT, applying to law school, I just sent in my last application a couple weeks ago, so I'm more than happy to share my knowledge and wisdom with you.
And hi again, I'm Sydney Leiferman, the vice president. Again, reach out to me if you need anything. Jordan and I will be gone in just another semester, which is really sad, but yeah, reach out to us if you need anything.
Hello, ladies and gentlemen. My name is Mikhail Mikhailov, also known as Mikhail, also known as Misha. This semester I was your treasurer, and that was an honor. I'm excited to see what the next semester holds as well. It was amazing to see everyone participate in various events, at various activities. And like I said, it's going to be an amazing semester up in the spring. So now I'll pass it over to the secretary, Miss Davis.
Hi, my name is Peyton Davis, and I'm your secretary. Thank you all so much for coming to all of our events this semester, and I'm super excited for spring.
Awesome. Thanks, guys. So we're going to get into membership requirements. Just as we mentioned in the past, directors are required to have 55 points by the end of the semester, and members are required to have 40 points. You already know GBMs are 5 points, in-person director events are 4 points, Zoom director events are 2 points, and special events are 5 points. We had our amazing banquet last night that went really, really well. Kudos to the special events directors for throwing one of the best banquets I've ever been to. It was awesome. And if you didn't receive your copy of your membership certificate, you can message Peyton and she'd be happy to send you a virtual copy. So you could print that out, hang it on your fridge, whatever you want to do. Mine's hanging in my room. So definitely reach out if you did not receive that last night. And then as well, Mikhail also has graduating cords for members that are graduating this semester. So in the fall of 2022, make sure to reach out to him if you haven't received that already. You could take some really cool grad pics with those. So again, message Peyton and Mikhail for those two.
Yes, I know that I already gave out some cords during the banquet, but if you haven't, if you weren't able to receive them then, please email me, please let me know, and I'll definitely try to schedule something together with a lot of folks so that I can hand them out there and then. But one of the amazing benefits of actually being an active member is our Test Masters discount. And as you can see, there are 3 options on the screen for a discount. The $400 discount for the actual classroom LSAT course in person, another $400 discount for a live online LSAT course delivered through Zoom, and then an asynchronous version for $200 of a discount. In order to actually receive it, you have to fill out the form pinned on the Facebook profiles that we have, and of course, you can only have 1 Test Master scholarship per semester. And of course, we also have 1 Test Master scholarship that for the person who received the most active points, and this time it was honorary Anthony Esquivel. Thank you, ladies and gentlemen.
It's a big honor. Thank you guys so much.
And with that, I'd also like to take the time to announce that Anthony will be our new law-related director for the spring. So another congrats to Anthony. We're really excited for you to step up in that role. And also congratulate Maria. She sadly will be leaving us, but she has a great opportunity in Tallahassee. So congrats to both of you guys.
Okay, and then our Google Calendar is ufprelegal@gmail.com. I just put in the GBM dates for spring semester, so if you add that calendar, it'll be in your calendar already. Don't have to worry about it, and we'll have a lot of great events next semester, so definitely keep up with our calendar. Okay, and then obviously tonight is our last general body meeting, and we'll show you the spring dates, and you guys can take a picture of that on the next slide. So yeah, these are all of our spring GBM dates. If they're already in the Google Calendar, but if you want to add them on your personal calendar, then they're all right here, so feel free to take a picture of that.
We'll now get into director announcements.
Let's start off with intramurals.
Hi guys, sorry for the delay. Computer is acting up a little bit. I want to say thank you so much for coming out to all of our events. We're going to have another bowling event, possibly even two bowling events coming up in the spring. We're going to be announcing some really interesting, cool collaborations, some other fellow organizations. So that's going to be new and interesting. It'll be really fun. Can't wait to see you guys there. I'm going to pass it off to Matt now.
Yeah, thanks, Jacob. I really don't have too much more to add. I'm just really excited for next semester and all the plans that we have going on for that. And thank you all for coming out this semester.
Mock trial.
Hello, everyone. I'm Sebastian, your mock trial co-director. And first and foremost, I just want to say thank you to everybody that participated and competed with us this semester. We all put in a lot of effort, a lot of hard work, and we showed up at both the PAD tournament and our own in-house tournament. And all of you guys, you did amazing. So seriously, thank you so much for joining us in this step and preparing yourselves for law school and your eventual careers as a lawyer. So thank you.
Special events.
Hi, everyone. Unfortunately, Peyton wasn't able to be here today. So on behalf of both of us, we just wanted to say a huge thank you to everyone who attended our banquet last night. We worked really hard on it. So seeing all of you guys there was really cool. And congratulations to Sebastian and Nirali for winning our very fun dance battle. And we cannot wait for our events next semester. So definitely keep a lookout for those.
Fundraising.
Hi, everyone. I just want to say thank you to everyone who came out to our fundraising events this semester, and we can't wait to see everyone in the next.
Public relations.
Hi, everyone. Thank you again for everyone all semester who has come out to table and help with all of that. I'm excited to get the pic from banquet, so look forward to seeing those on the Instagram whenever those come in. If you have any other pictures from any other events, please feel free to send them to me. And now I'm going to hand it over to Madison.
Hi, everyone. Yes, thank you again for everyone who tabled. I'm going to be sending again just the member and involvement spotlights really quickly, so I can keep filling those out. We can post as many of you as possible.
Law related.
Hello, I don't think Ariel's here right now, but on behalf of both of us, thank you so much for a great semester. Thank you to everyone who attended our events. Congratulations to Anthony. I know that both you and Ariel will be so amazing and do such great things next semester. And so keep on the lookout on what fun law-themed events they will do. Thank you.
Thank you, Maria. We'll miss you so much. And now for community service.
We just wanted to say thank you to everyone who came out to our events this semester. Be on the lookout. We have some ideas for next semester, so we're looking forward to it, but thank you guys.
Internal affairs.
Hey guys, so Freedom and I just want to say thank you for coming out to the event that we had last week. The painting event was super, super fun. And for everyone that voted for me, my free coffee goes out to you guys. I'll be thinking of you when I drink it. And we just want to say thank you for all the amazing people that came out to all of our events this semester. We had so much fun. Like I can't even articulate like how much fun I had with everybody. And yeah, I'm gonna give it off to Freedom for some fun little activity that he has.
Yeah, so kind of just building off what Nirali said, thank you guys for a great semester. I know it's been my favorite semester in PLHS so far, and that's because of all of you guys coming to our events and just having so much enthusiasm, which means the world to me. But right now, I just want to share some of the shout outs that we had for you guys that filled out that shout out form. Obviously, Anthony received a ton of shout outs, being our most active member. And everyone talked about how he just kind of threw himself into everything he did in the organization and had a lot of enthusiasm. So definitely shout out Anthony, and I can't wait to see him as a director next semester. Shout out Maya. She got a lot of love for making our shirts. And honestly, those shirts are so cool, 2 different colors. Like, I've seen a lot of people rocking them and they look great. So huge shout out there. Also Lane for working so close with the mentors and really like growing our mentorship program, which is so important to everything we do. So huge shout out there. Also a shout out to Trisha, a mock trial shout out one time. Trisha stepped in during the competitive tournament and the in-house tournament for people who couldn't actually be at the tournament. And she did that with like very little preparation and like on her own time. So huge shout out to Trisha there. It's not easy to do. Also, it wouldn't be complete without shouting out Sydney. She got so much love on our forum. Everyone just talked about how she was so positive, so reassuring. And as one of Sydney's directors, I can definitely attest to that. I don't know how my semester would have gone without her. And just one last one, certainly last but not least, just Brianna for being so organized. That's what everyone said in their comments, was how easy it was to work with Brianna and how, she always seemed to be on top of it. So yeah, we're definitely going to bring this back next semester and do more shout outs. But thank you to everyone who submitted it. It was really cool to hear all the love flowing through the organization. So yeah, thank you guys and have a great winter break.
That was so sweet. Thank you guys so much. Freedom and Raleigh, also shout out to you guys for making our TikTok. If you haven't followed us already, they've been sending some of the TikToks in the group me. So definitely check us out on there. With that, we'll go to Mentor Mentee.
Hey everyone, on behalf of me and Lane, thank you guys so much for making this a fun semester. We can't wait to see you all next semester if you hopefully join Mentor Mentee, and good luck on finals and happy holidays.
Thanks, Alex. Okay, finally for diversity.
Hey guys, so sorry if I sound weird, I'm in the car. Just wanted to let you know that we really appreciate everyone who came to our events, and thank you so much for doing so. And we have a couple exciting ideas and plans for the spring semester. So we look forward to seeing you all then. Thank you so much.
Awesome. Thanks again, directors. We had an awesome semester and some great events.
And now for our final speaker of the fall 2022 semester, please help me give a virtual round of applause for our guest speaker, Randall Abate. Everyone, thank you. Please welcome him. Wait, let me pin him real quick before I give his introduction. Okay. Oh, I accidentally pinned Lane. Where is that? Jordan, can you do that for me, please? Sorry. Okay, so I'm just gonna go ahead and give the introduction. So Dean Abate is the Assistant Dean for Environmental Law Studies at the George Washington University Law School. Prior to joining GW Law in July 2022, he was a full-time law professor at 6 U.S. law schools. Dean Abate has taught courses and delivered lectures on environmental and animal law topics in 26 countries and at several of the top law schools and universities in the world, including Harvard, Yale, Cambridge, Oxford, Columbia, Penn, University College London, and the University of Sydney, McGill, and oh my God, there's so many. University of Toronto, Seoul National University, and China University of Political Science and Law. Oh my God, I had to take a breath on that one. He has published 6 books and more than 35 law journal articles and book chapters on environmental and animal law topics, with recent emphasis on climate change law and justice. So everyone, please give a very warm welcome to Dean Abate.
Thank you very much for that kind introduction, Sydney. It's great to be here. Great to see so many of you out at a time that's got to be very close to finals, right?
Yeah, we had our last day of classes today. So finals, some people have already taken some people are doing that next week. So yes, thank you everyone who's come out. Yeah, it may not be the most convenient time, but yeah, thank you all.
Yeah, I'm grateful for that as well. So I want to make this worth your while and give you some hopefully engaging, uplifting, perhaps mildly depressing discussion of a topic that's very near and dear to my heart. So I just want to say thanks to all of the e-board members for PLHS. I'm really excited to be here. I had the privilege of meeting Sydney and some other folks at the UF Professional Graduate and Professional School Fair in October. And it's been great building this connection, staying in touch with a lot of UF students and their interest in law school. Generally, their interest in GW law in some instances. And I'm just really excited to be able to be a mentor and hopefully a source of inspiration as you consider your law school journey ahead. And I realize that many of you may not have come to tonight's session thinking that environmental law or climate change is an area of interest for you in the future. And if just one of you leave tonight's meeting feeling perhaps environmental and climate change issues are more interesting than you thought they were, I feel like I've done my job, and certainly hopefully extending the enthusiasm of those of you who are already excited about these issues. So as the title of the presentation suggests, this is a presentation for you and your generation. It's a topic that I've spent a lot of time on recently as in the past decade or more. It's one that's getting a lot of attention in the law generally, but in particular in the courts, about how climate change is this crisis that affects disproportionately burdened sectors of our society more than the rest of us, so to speak. And so I've done a lot of work on certain of those communities in other scholarship and teaching. So the impact on racial minority communities, low-income communities, the impact on indigenous peoples, the impact on non-human communities. I'll touch on that briefly tonight, wildlife, natural resources. But tonight's focus is on the vulnerable human communities of youth, and that's a term that's difficult to define, sometimes referred to as future generations. So I want to give you a roadmap of what I'd like to address tonight, and I want to start by giving you just a very short synopsis of where environmental law is right now, where it's been and where we are now, and how this new place of how environmental law is working is a very potentially valuable opportunity to do a better job protecting future generations. And then I also want to talk about how climate change is something that we have to consider not only as a daunting threat, which it is, but also as a potential opportunity for change in how the law works to protect future generations. And most importantly, to get anywhere in our discussion, we have to define what we mean. Who are we referring to when we say the term future generations? And I'll take you through a little bit of history there about cases that have involved protection of youth and future generations over the past several decades, and where we are right now with the youth climate cases that are dominating the courts all over the world. And very briefly at the end, depending on time constraints, I want to give you just some proposals for how the law can be more protective of youth and future generations' interests. And it's very important to start from that proposition that most of the people we think of as future generations are not able to vote. And that's a huge foundation of vulnerability when we think about how climate change affects the interests of those who are not yet able to vote, how much more of a challenge climate change is. They can't play that role in participatory democracy to protect their interests the way those above the voting age can. And I want to conclude with a thought about how the courts perhaps are not the best place to protect future generations, but they play a valuable role nevertheless. So this slide about the paradigm shift that's happening now in how we govern the earth and environmental problems, it started basically in the 1970s, and that's what I'm referring to as a period of anthropocentric environmentalism. So this is the environmental law that most of us have come to know for most of our lifetimes, really, those in my generation. Environmental law exploded in the 1970s in the US. And it wasn't because all of us just decided we needed to love Mother Earth more, that we had all these laws coming into being in the 1970s. The Clean Air Act, the Clean Water Act, our hazardous waste laws, and many others. They just exploded onto the scene in the 1970s. So the reason why these laws were able to get that political will and come onto the scene so quickly was that there was a recognition that our human activity was trashing the planet. Environmental pollution was happening in all forms, everywhere. And science was telling us that that pollution had a very severe health and safety impact on us as humans. So environmental law wasn't about, we think of nature as having intrinsic value and therefore our laws need to do a better job protecting non-human entities like wildlife and trees. But rather we were very invested in protecting ourselves, and that's how environmental law took off. It was really designed to ensure that our pollution of the world around us was not going to threaten our health and safety as humans. So even though that was applauded as this great advance in environmental protection, it was doing more to protect us than it was to protect the environment. Many of our environmental laws are essentially designed to be this permitted continuation of pollution in the environment. So when you think about how the Clean Water Act works, it's not our waters are polluted, therefore no more pollution. It's set up in a way that allows permits to be granted to continue to pollute just in certain quantities. And so that's not a really sustainable way of thinking about how to protect resources when we're just continuing to allow the status quo of pollution just in more regulated quantities. So from there, in the late 1980s, early 1990s, we saw a transition happening where environmental law really wasn't just about limiting the pollution impacts to the general public. We started to see that certain populations in the public were getting more burdened than others by pollution. And so this is what gave rise to the environmental justice movement. It initially was focused on Black communities, primarily in the Southeast United States. And basically studies were conducted where whenever there was anything environmentally undesirable, whether that be heavy industry or landfills or medical waste incinerators, almost in every instance, you could find a Black community very much in the vicinity of that environmentally undesirable use. And that certainly expanded beyond that focus on Black communities and went also to include other racial minority communities, low-income communities, indigenous communities. Basically, what those communities had in common was a lack of political power and a lack of economic resources to fight back against having those facilities sited in their backyards. It's nearly impossible to find a landfill in the backyard of an affluent white community. It just doesn't happen. They're too politically and economically powerful to allow that to happen. So this was the environmental justice movement, and this evolved in many ways into what's now known as the climate justice movement, because a similar reality is happening with climate change. We are looking at a problem that's global in nature, but it's having very selective, disproportionate burdens on communities at a global scale and a local scale. So globally, you look at the Arctic, you look at the South Pacific, you look at developing countries in Africa. These areas are getting disproportionately burdened by the effects of climate change, very much like what we saw in environmental justice in the US. The idea that environmental problems are not evenly distributed among the populations. And then we're also seeing this among indigenous communities in the Arctic, the melting of the Arctic, displacing those communities. So it's happening at a full national level and also on a subnational level, this disproportionate burdening. So from there, we're now into this era that's very much about rights-based protections. So part of that is coupled with this desire to have the governments of all countries do a better job protecting the vulnerable and to allow those vulnerable communities to have legal rights that enable them to fight back when the government isn't doing enough to protect their interests, to be free or limited in how environmental harms affect them. So that's really where we are now with these future generations lawsuits against governments. That's really what's happening. You've got a disproportionately burdened community of young people saying our future is being stolen if the government doesn't act more ambitiously to regulate climate change. We aren't going to have much of a future to look forward to. And so we're trying to find ways to use the courts to compel the government to do a better job protecting our interests. We can't vote the people out of office who are not caring enough. The courts are really our last resort to find some justice in all of this. And speaking of not having a future, those of you who are thinking of staying in Florida, you should consult with me about considering buying property anywhere near the coast in Florida in your lifetime. When I moved to Florida in 2006 to join the faculty at Florida Coastal Law School in Jacksonville, a lot of my environmental colleagues up north thought I was crazy to be buying property within 2 miles of the Atlantic Ocean in Florida in 2006. It's 2022 now, and situation is much more stark. 20 years from now, you may not even be able to afford the flood insurance to live near the coast, even if you want to. So hopefully that will make you pursue a more honest and sensible decision about that, because it's not a matter of whether, it's a matter of when Florida is going to be severely flooded to the point of not being habitable the way it is right now. And that raises all kinds of interesting human rights issues as well, not necessarily about youth rights, but more about migration issues. Just think about where the population of Miami and Fort Lauderdale is going to go when South Florida becomes uninhabitable. I lived in Orlando for close to a decade, and Orlando's already overpopulated and is already facing water crises. Think about where are those people going to go from Florida and from Miami and Fort Lauderdale. It's going to be a massive climate migration crisis. That's not just a crisis for Florida, but it's going to be a crisis for the whole country. That's not something that's going to be addressable the week after it happens. That's going to require decades of planning to get in front of that. So when you think about climate change, that's often what you hear about, those kinds of gloom and doom projections, which are frankly quite accurate and need to be considered seriously. Climate change is certainly a common enemy to all of us, but when you think about law reform, climate change might be that opportunity that future generations need for the law to be more sensitive and responsive to their needs. That whole paradigm shift that I mentioned about ecocentrism as where we are now, thinking more about intrinsic values of vulnerable communities, whether they be human or non-human, that is something that climate change is almost forcing us now to think about as a way the law can work. And that is the idea that we're all in this together, whether we're living in the US or in a country halfway around the world, whether we're human or non-human, climate change is threatening all of us, and the law needs to be thinking about all of us as this interconnected whole. That climate resilience is all about relying on non-human communities to help protect human communities. So we need to be thinking holistically. We need to be thinking about how future generations are going to be the stewards of everything in the future, and therefore they need to have the legal protections to be able to do that effectively if we care about continuing to have a habitable planet. So what do we mean by the future generations? all of you are future generations. We can start there by just about everybody's definition. Many legal definitions have looked into young adulthood as being part of future generations. It's not just kids who can't vote. It's not just those yet to be born. You, in fact, in your 20s are future generations. And there was even a case in Canada that considered future generations for purposes of a class action to be the age of 35 and younger. For what we mean by future generations. So there's no right answer there, but ultimately it's a very broad group when we think about the scope of age from potentially 35 to yet to be born. That's a big sector of the population that's in need of better legal protections against climate change. So when we look at what the law has done to protect these kinds of concerns in vulnerable communities like youth populations, there's a major case that was super inspiring. This case was going on right when I came out of law school, and I met this attorney who was very early in his career. He's a legend now, Tony Oposa from the Philippines, and he brought this groundbreaking case in the Philippines on behalf of current children and children yet to be born. And the basis of the case was that the government of the Philippines was issuing what were called timber licensing agreements. They were essentially just selling off the tropical rainforests in the Philippines at an alarmingly fast rate. And of course, the tropical rainforests are so valuable to the people of the Philippines, not just for their value as carbon sink to respond to climate change, but they're havens for biodiversity, they're havens for cultural values. They are certainly a place where much of the identity of the country is rooted. And so the government's issuing of these licenses to essentially mow down these tropical rainforests in a period of decades was alleged to be a violation of these plaintiffs' constitutional right, recognized in the Constitution of the Philippines, to a healthful and balanced ecology. This is very kind of broad, aspirational language in the Constitution of the Philippines, that all citizens of the Philippines have this right to healthful and balanced ecology. And so what was really profound about this case was that these plaintiffs, who themselves were not going to be able to represent themselves, these were kids and people yet to be born, actually were determined to have standing to bring this case. They had an interest that the court could recognize as something the court could address in a legal dispute. And ultimately, more impressive still, the court concluded that action that the government was doing, the issuing of those licensing agreements to chop down the forest, did constitute a violation of that constitutional right to a healthful and balanced ecology, which is really amazing when you think about it, because this right in the Constitution says nothing about deforestation. It says nothing about what that really means. What does it mean to have a right to a healthful and balanced ecology? So this is where the courts can be really valuable in assigning meaning to something that's framed quite generally in a constitution or a statute, and the court can give it more meaning than the words themselves might suggest, and that way the party seeking protection can really benefit. And in this case kind of set the foundation for everything we're seeing now, 30 years later, in these courts around the world involving youth climate litigation. So I wanted to give you some of the highlights of that progression that we're seeing recently in the courts. And one of my favorite cases is very much inspirational, like the Philippines case, the Oposa case that I just told you about. And this came out of Colombia in 2018, I think. And here we had a group of youth plaintiffs, all of them younger than you are, being represented by an attorney, a young attorney who I know and interviewed for my book, She was 26 at the time when she brought this case against the Colombian government. And basically, the argument that the youth plaintiffs were making in this case is that, similar to what we saw in the Philippines, we had the government of Colombia enabling the destruction of the Colombian Amazon at an alarming rate. So the year before this case was filed, deforestation in the Colombian Amazon had increased by 45%, and which is just crazy when you think about it, that the Amazon is known as the lungs of the planet. I mean, we, not just people who live in the Amazon, all of us on the planet need the Amazon to be intact if we want to have a fighting chance against climate change. And the government of Colombia was just allowing private interests for short-term economic gain to just mow down the Amazon for palm tree plantations and cattle ranches and the like. And so basically the youth plaintiffs said, this is enough. We want to find a way to compel the government to stop this from happening. And so they had a very ambitious claim to say that the government must stop this deforestation, not reduce it, but reduce this deforestation, eliminate this deforestation. Deforestation should be brought to zero, which sounds like just some 8-year-old's dream before bedtime. And the case was successful, and it relied on some very similar creative lawyering like we saw in the Philippines case, about using the Constitution, some broad language in the Constitution about a right to health and a stable environment and so forth. And that language was a big part of what the court relied on to grant the youth plaintiffs their requested relief, to compel the government to stop deforestation. One of the challenges in bringing these very ambitious strategic cases is that it's only a court's judgment. It doesn't mean it's going to happen tomorrow that this is going to stop. And in fact, we're 5 years after that decision, entering 2023 in a few weeks, and that decision has not yet been implemented because there's so much resistance, so many drivers of deforestation in that country, that the political will to enforce that decision has not yet manifested. What was really profound about the case, though, was that the court was so behind the protection of the youth's interests that it decided to assign legal personhood to the Colombian Amazon, which is really unheard of, for a court to do that without the plaintiffs asking for it. So legal personhood is a way for the law to recognize an entity as having legal value in its own right. So there have been a lot of cases around the world that have been recently embracing this concept. So rivers in India and in Colombia, in a different case, have been granted legal personhood. And this means that they have the right to be represented as an entity, like a human, and have their interests protected in court. So the court itself decided that the Colombian Amazon should be granted legal personhood, so it could be better protected from the drivers of that rampant deforestation. And even that hasn't been enough to get the outcome yet, but it's a big step forward. And in Canada and the US, there have been some very high profile cases at the federal level in each country that did not succeed, but were very important in getting a sense of what's possible in using the courts to protect future generations' interests. So in both cases, it was an effort to try to compel the government to raise its ambition and being more strict about regulating climate change. And then it also, in each case, sought to have some kind of rights-based argument that the failure to be more ambitious about regulating climate change was actually violating constitutionally protected rights in Canada and in the US. And interestingly, in the US case, the allegation about the right that was being violated was characterized as a right to a stable climate under our Constitution. And if you've read the Constitution, you're not going to find that language in our Constitution. The right to a stable climate is something that the plaintiffs were reading into the Due Process Clause. of the 14th Amendment, and that basically just says life, liberty, and property shall not be violated without due process of law. So a lot of other rights that we now claim as our constitutionally protected rights have their foundation in the Due Process Clause. So until recently, that was a woman's right to choose. Hopefully that's not gone forever. And that also includes married couples' rights to use contraception. That's included right to marry and even right to same-sex marriage more recently. And so basically the plaintiff's argument was, in that same-sex marriage case in 2015, the argument was that marriage is so fundamental to how we engage in society that it's just a platform for all of the other rights to be exercised. And therefore it would be improper not to extend the right to marry, constitutionally protected right to marry, to same-sex couples the way it is to heterosexual couples. So the argument in the plaintiffs in this case was similar, saying that what could be more fundamental than the right to a stable climate? All the rest of our constitutional liberties are meaningless if we don't enjoy the right to a stable climate that the Due Process Clause ought to protect. That argument didn't win, but it was an important argument to make when we think about how rights-based protections might protect youth more effectively in the future. So what we're seeing now is different versions of these theories, both in US and Canada, that were against the federal government. They're now being asserted at the state government level in the US and at the provincial government level in Canada. And those are having more success. So those are still pending now in the courts. So just briefly, some ways the law can do better. Like I said, these court decisions are really groundbreaking. They're raising lots of publicity about the issues, but we're not going to address climate change one case at a time. We'll all be dead. So the law needs to get ahead of this in a way that court decisions can't. And one way of thinking about that is that we need to think about what sustainable development means. And we look at the definition of sustainable development. Way back in the 1980s, it was defined to include the protection of future generations, baked right into what sustainable development means. It's all about ensuring those needs of future generations are met in how we go about making decisions today about our development initiatives. So really, for the past 30 years, that language has been kind of aspirational rhetoric. It hasn't been considered binding on actors, whether they be government or private sector actors. It's just sort of this window dressing for how we ought to behave. And we're at a point now where the law can make this a more mandatory requirement when applying it to proposed ways that we're developing. And climate change may be the reason we have to go that way, to make it binding. So this slide just briefly overviews how environmental considerations, it's relatively recent that we've thought about the environment when we make development decisions. When I was growing up, it was all about development. Development was a great thing. Economic growth was a great thing. We didn't think about the environment being anything but an all-you-can-eat buffet. We were just going to develop it. It was so vast and unlimited that there was no reason to think that the environment was going to let us down and limit our ability to get rich and comfortable. So this second era is the sustainable development era, where we realized, you know what, it's not an all-you-can-eat buffet, and we have to be thinking about the environment as we develop. It's not to say we should just all be hippies and live in the woods, but it does mean that development is something that comes at a price, and there has to be an assessment of that price factored into our development decisions. And now we're entering this era where sustainable development's been kind of institutionalized in the way governments have thought about development now for 3 decades. And there's an argument under international law that it is now customary international law, which means states are doing it as if it's required to do so. And that means it does develop a kind of binding quality. And that's a much longer discussion for law school about how international law is in many ways very different from domestic law. But the idea is that it's not so radical to say sustainable development should be required and not merely an aspiration when we think about protecting the interests of future generations. So how would that work? In climate change, there's an easy way that science can help us make it work, and that is the idea of there's a carbon budget that each country works with when it's in a party to the Paris Agreement. There's a certain amount of greenhouse gas emissions that you can emit and meet your goals under the Paris Agreement. And so a very simple way of applying sustainable development to that idea is that if there's a project that is going to involve significant greenhouse gas emissions over a period of time, that would take the country out of its carbon budget, that project should be rejected. No permit should be granted. That should be considered unsustainable. So there's a way that science can inform what sustainable means, and the law can require us to act only in sustainable ways when it comes to climate change. And of course, that could happen across many other contexts as well, not just climate change. And there was a case in Australia that actually applied that reasoning, which was really powerful. It was about 5 years ago, where there was a major coal mine that was being proposed, and the court in that case relied on this logic and said, you know, this coal mine is just massive. It's going to be exporting coal from Australia around the world, and it's going to take Australia, and it's going to be used in Australia as well, and it's going to take Australia out of its carbon budget compliance, and therefore the permit was denied. And that thinking can be applied all over the world when it comes to development efforts that are going to take a country out of compliance with climate change mandates. And so this is how it can be linked back to protecting future generations. Future generations need that kind of strict mandate that says, if our future is going to have any hope, these development decisions have to be very strictly regulated. We can't go about it the way we used to, because that's why we're facing this planetary emergency now. And that's going to be very helpful if the law can adjust how strict it is with future generations' interests in mind and be more protective in thinking about what sustainable development means. And procedurally, we already have commissions in several countries around the world that are groups of adults that are looking out for the interests of future generations. So they inform legislative bodies about proposed legislation and whether that's adequately considering the interests of future generations. And they're also involved in court proceedings to be the voice of future generations in how court decisions are ultimately resolved. So there are also ways that the law can recognize that there is intrinsic value in those yet to be born. And this is a big scholarly debate about whether and how the law should assign legal rights to people who don't yet exist. I was a philosophy major. I spend a lot of time thinking about these things, but if you go beyond the philosophical question and go to the legal question, it's very difficult. When you think about it, just the abortion debate alone, it's very difficult for the law to say a human that does not yet exist nonetheless has legal rights. So I'm sure you're familiar with the idea of that debate about when a human is protectable, when the fetus is protectable, and how that evolved in the court's jurisprudence. It wasn't upon conception. That's just a bundle of cells. That wasn't considered something that has legal protections. But when it evolves to be viable outside the womb, then that is something the law recognizes as protectable. So it seems like a strange standard that you have to be a certain progression along in a pregnancy for the law to recognize that you have value, even though you're not yet born. It's very similar to the idea that the law has already recognized non-human entities as having value and deserving of legal protection, like with the rivers and the forests having legal personhood. Even artificial intelligence in Europe is getting assigned legal personhood, and another example of non-human personhood. Ships have personhood as well. So it's not so radical to be thinking about humans yet to be born as having rights that deserve to be protected. And then there's procedural mechanisms in our own federal rules of civil procedure that allow a plaintiff to represent the interests of a next friend. And the idea here is that that next friend is someone who is not able to represent their own interests. So typically this would be used for one human to be representing a human who's in a coma, let's say. But the reference is to person, and we shouldn't assume that person means human. Person means legal person, and a legal person can be any of the things we discussed. So that mechanism has not yet been recognized by courts to extend to trees and rivers and yet to be born human. But it's up to us to decide person means more than human and enable the protection to be much broader, to have a better impact in protecting future generations' interests. So all of those mechanisms exist within the law, and a lot of it comes down to where's the political will to be able to have those court decisions and those legislative developments that show that we are serious about recognizing the legal personhood of future generations at all stages. So closing thought on the courts and their role. There's a big debate about how courts should not make law, and that's a very good point. Our courts are designed to interpret the law. So when you think about that case in Colombia where the court came out and said, we're going to declare that the Colombian Amazon has legal personhood, that's a very sensitive issue because many would say that's not the role of the court to do something that the parties didn't ask it to do. That's for the legislature to make law. And so there's a lot of that lawmaking going on in these climate justice cases involving future generations and others, where the argument often is that the executive branch, because climate change is a global issue, the executive branch should be making laws about climate change, or Congress should be making laws about climate change. It's not for the courts to do that. And so the other challenge is that when you get these big strategic outcomes in the courts, it often takes a very long time to implement. They're very politically controversial, and sometimes they never happen. Sometimes they get reversed. So that's not very effective in addressing climate change. It's very lengthy and costly to go through this process using the courts to get some protection for climate change and future generations. So what's important though about these court cases is that they've been a great source of publicity for the cause. And when I look at the Inflation Reduction Act that was just passed in Congress, I did not see that coming. I mean, I had resigned myself to the fact that I live in a country that is one of the leading polluters, leading contributors to climate change, and we're never going to have climate change legislation of any kind. So 30 years we went without climate change legislation, and then just this year we have it. It's not nearly as ambitious as it should be, but we have it. And my feeling is that without these cases in our courts for many, many years, raising awareness of how important protection of vulnerable communities is and how urgent the climate crisis is, we probably wouldn't have had the political will in Congress to get the Inflation Reduction Act passed. So that's the value of these cases, that they are such a valuable source of awareness building, movement building, and it doesn't matter so much whether you win that case in the court that day. It's about what that ultimately leads to in Congress and in the streets, basically, about raising awareness about climate justice issues. So I close with this slide of an adorable little girl that I took a photo of when I was at COP26, the annual climate change meeting of countries around the world in Glasgow, Scotland last year. And it just made me think, you know, when I was her age, I was just playing football in the backyard without a care in the world. And this is, in the span of my lifetime, her generation is going to bed at night wondering what else she can do to advocate to protect her future and get better protection of the climate change issue. So that's really stark and unsettling, but it's also very motivational that, you know, we do have the ability to do a better job and ensure a safer future. And it's up to you and your generation to be the leaders on that. So I hope many of you do some kind of work in that space. It doesn't mean you have to devote your career to it, but just local initiatives, pretty much anything that addresses a regulation of climate change on any level of governance is going a long way to make the world a safer place for those who can't protect themselves. I look forward to hearing your questions, and then we can also talk about law school questions as well.
All right, so does anyone have any questions? I have one question, so I might go first. Oh, wait, we do have questions. I'm gonna hold my question for a little bit. Drew, I saw your hand first. Go ahead.
Hi, so thank you first of all for coming. I really enjoyed the presentation. I took a class last semester on rising sea levels, and a big part of that class was obviously like the legal proceedings around it. What, if any, are the solutions for, as you talked about, the minority communities always being surrounded by environmental hazards? Like, is there a way to either prevent that in the future or kind of right the wrongs now? Because obviously a landfill is like a very big thing to try and like move or relocate a community is a major process. So really, like, what are the processes for going around that?
Well, that's a very good question. So when you think about sea level rise, this is something that's inevitable. This is driven by science, whereas where we place our landfills is driven by political will. So what's really daunting about sea level rise is that it's going to create, if the law doesn't intervene adequately, it's going to create this kind of social Darwinism where those who are wealthy and politically powerful will find ways to protect themselves from that threat much more effectively than those who do not have those economic and political resources. So to give you an example, in Florida, again, South Florida is really very much one of the most vulnerable places on Earth, not just in the U.S. It's considered, I think, the fourth most vulnerable place on Earth to sea level rise. So what we're already seeing is that people are finally wising up a little bit, and we're seeing wealthy communities that are very close to the ocean's edge in Miami retreat back into areas like Hialeah. And basically what this process is called is known as climate gentrification. So basically the rich people will find the next safe place to go. And by their intrusion into that less wealthy community, they're essentially displacing the existing residents who can no longer afford to live where they called home. And when you think about that, it's not like they're being physically evicted, but it's the infrastructure that comes with the wealthy. So, the grocery stores are going to be too expensive to buy your groceries. You're not going to be able to afford a cup of coffee at that gourmet coffee shop. It's going to completely transform what it means to live in that town, and from an economic and a cultural perspective. So that's the problem, that the law can ultimately build in protections to avoid climate gentrification from happening to the degree that it does, or we can just allow the rich and politically powerful to win and the rest of us get trampled. Sea level rise is going to cause that kind of social disruption, and we know that if we've read 2 sentences of the science, and it's a question of building that political will to get the hell away from the water. And that's really a hard message to convey in Florida. Everyone wants their ocean view, and you're going to love that ocean view so much, you're going to be a part of the ocean. That's the best ocean view ever, apparently, because they don't see that risk of this is imminent. This is in the lifetime of those homeowners. If they don't move, they will drown. And whether it's a 20 or a 50-year window, that's what's projected for South Florida.
Thank you. I hope that helped, Drew. So I'm going to go with Mikhail first, and then I'll do Lauren, and then I'll do Natalie, if that sounds good. So Mikhail, go ahead.
Yes, thank you, Sydney. First, I'd like to echo what Drew said and just share my gratitude for your presence here and for you to take the time to answer our questions. My question is as follows. Do you have any advice for students who'd like to promote civil discourse when it comes to topics of sustainable development in our local community?
Yeah, that's a great question. I think a lot of this is more education first. and then advocacy. So one development that I found really compelling when I was teaching at Monmouth University in New Jersey before coming to GW this year is that New Jersey is the first state to require climate change education across the primary and secondary schools in every subject. So when you think about how powerful that is, if you've grown up with the idea that climate change is everywhere, it's in math, it's in science, it's in English, it's in social studies, it's a part of how you interface with your world, then it's going to be very easy to have that advocacy step. After the education foundation is there, the advocacy is not whether you're going to care about climate change and do something about it, but how are you going to do it? And it can happen on a lot of levels, just locally. It's about advocacy for the way you live your life in a more carbon footprint friendly way. So that's about sources of transportation, where you live, energy choices generally, and ultimately going back to more of a urban way of living rather than suburban. Suburban is a nightmare for the planet. When you think about golf courses and McMansions that are on 2-acre lots, this is the most and pavement everywhere. I mean, my dream is that within the next decade, sorry for you shoppers in the audience, but we would make such an impact if we convert every shopping mall and parking lot into green space. The impact that would have on climate change would be remarkable. And many of these places are half closed down anyway. I mean, who wants to shop at the mall anyway? So there's so much about suburban infrastructure that did so much to cause climate change to be worse. I think a lot of the advocacy has to be about, kind of like that mantra when you visit a national park, take only pictures and leave only footprints. I mean, we have to live in a much more environmentally friendly and sustainable way. And that starts with education, and then all forms of advocacy in every way that we live our lives with your family, friends, and colleagues. That's a discussion that should happen every day.
Thank you so much.
All right, Lauren, go ahead.
Hi, Dean Abate. I spoke with you a couple weeks ago when you came to UF, so thank you for being here. I was looking forward to this talk. So I'm really interested in business law and how it intersects with sustainability initiatives. And so I've done a lot of research into corporate social responsibility. And so today you were talking a lot about how we can use the courts to compel governments to do a better job. So I'm interested on hearing your take on where private companies fall into this, because they are now taking more and more initiatives to integrate these environmental concerns into their policies and operations. So do you think that businesses can help compel governments the same as courts, or courts will help compel businesses? I'm just interested to hear your take on that.
Yeah, that's a great question. I really see businesses as the answer. And it's a lot of people think, well, I'm not a greenie hippie, so I'm not going to be able to help the climate change issue. I mean, really, where the resources are is we need to rethink how we are developing the planet, and business in a way that is environmentally sustainable and sensitive is really much more impactful than really anything the government can do in the US anyway. I mean, the US is just always going to have these tiny baby steps forward when it comes to governing an issue like climate change. So I think there's a carrot and a stick side to your question. So on the stick side, corporations have already done so much harm when it comes to climate change. The statistics on this are daunting. There was a study conducted that basically about 2/3 of global greenhouse gas emissions are attributable to about 100 companies worldwide. So that's a very short list of culprits to sue if you want to promote accountability, and they're getting sued like never before. So there's all kinds of accountability litigation going on now in the courts against the fossil fuel industry. And you're thinking, why are we suing the poor fossil fuel industry? Don't hate them because they're rich. Well, here's what happened. They had the science on climate change. They actively disregarded what they knew about climate change. They had the evidence that said way back in the 1980s that climate change will cause greenhouse gas emissions from oil production and consumption will cause this climate catastrophe, which we're now experiencing. And not only did they ignore that science, they actively campaigned to deceive the public about the clarity of that science. So the public was robbed of an opportunity to advocate against the use of oil to power our lives, oil and coal and everything else. So ultimately, the fact that they knew it, ignored it, and actively deceived, there are all kinds of causes of action now in common law litigation that's alleging fraud and conspiracy and even criminal liability in some instances for this conduct. And the writing's on the wall. I mean, these cases are proceeding to trial, and that alone is a victory because all that dirty laundry is going to be aired for the public to see what they knew, when they knew it, what they did with that information. And you're already seeing these corporations transition voluntarily to other kinds of green energy because they're not stupid. They want to remain profitable, and they know that there is a limited window on how long we're going to be able to rely on fossil fuels and ultimately sustain ourselves. So there's all kinds of pressure for them to transition as quickly as possible. On the front end, though, where your careers could really make a difference is this idea of ESG and making the way companies do their business in a more environmentally sustainable way. And that's going to go a long way, just like the back end kind of litigation will, to try to make them financially responsible for how much they contributed to the problem, getting them in whatever they do moving forward to be more environmentally sensitive is every bit as important and something that you could easily build a career around these days. There's all kinds of opportunities to work in the private sector, not be considered the bad guys, but you're doing good work from within instead of throwing rocks at them from outside as the David versus Goliath litigators. Both sides have to happen, and quickly.
That was a really interesting take. Thank you. I actually was wondering that as well. So thank you, Lauren, for asking that. Natalie, go ahead.
Hi, thank you so much for coming and speaking. Kind of on the ends of what Lauren was saying. So I know that now it's a lot harder to get things, number one, passed and regulated on the federal level. So what's the role of environmental law at like the state and local level where it might be a little bit more achievable to meet some of those goals?
Yeah, that's a great question. So to go back to the 1970s, the reason why we needed these federal environmental laws was prior to the 1970s, we had this patchwork of state laws. You know, some states were being ambitious about protecting the environment and others were not. And so not surprisingly, we saw all the polluters migrating to those states to do their business where the laws were not strict. So we needed that uniform federal mandate on protecting the environment. But what we're seeing now, particularly in the past 20 years in the US, is that it's so hard to get anything done at the federal level that's protective of the environment. And there's such an urgency to do so that we're seeing some very successful efforts at the state level to get the right thing done, which is far better than nothing. And the best example of that is the state of California. If California were a country, it would be the 5th largest economy in the world. So the fact that California is getting it right is a very big deal, not just for the US, but for the world. This is a major economic player in the world, and they are doing just about everything right on climate and energy. And we're seeing other states follow California's lead on a lot of these initiatives that are climate and energy regulatory frameworks. And that's far better than nothing. We're seeing a similar reality in the courts. So it's harder to get that relief in the federal courts. So we're seeing cases now that are achieving relief at the state court level on climate change. And again, that's better than nothing. So we have to keep being strategic and creative and patient. To be an environmental lawyer, you have to have all those qualities because it's never going to happen the way it should, but with your creativity, patience, and persistence, it's going to happen in some form, and that's going to be good enough.
Thank you. That was a really interesting question, Natalie. Thank you so much. I think we have time for maybe 1 or 2 more questions. Maria, I'll take you, and maybe we'll see if anyone else has something up. Go ahead.
Hello, thank you for doing this presentation. It's been very, I remember like, this was like years ago back in high school, but I remember in like one of my science classes learning about the like the ozone layer crisis, when everyone learned that our ozone layer was being depleted. And because of that, there's been a string of like a lot of laws passed by various governments to like slow and decrease that depletion. And so that experience, I guess, to the ozone layer crisis, like, I guess, what can we really like learn from that and like apply it to climate change is really my question.
That's a great question. And it's one I teach every time when I teach international environmental law. So what's interesting is that these are apples and oranges when we think about stratospheric ozone depletion and climate change. And there's really three reasons for that. The first is the science. So on the science, there was a very clear cause and effect relationship as to why our stratospheric ozone layer was getting depleted. We were releasing a substance called CFCs, chlorofluorocarbons, and there was a direct cause and effect relationship between the release of those chemicals in a very narrow sector of our economy and the thinning of the stratospheric ozone layer. So that's a really easy fix, and that goes next to the economics of it. The fact that it was a narrow sector of our economy that was also willing to work with scientists to come up with an alternative, not only did they fix the problem, but they maintained their economic viability because they switched from CFCs, which were harmful to the ozone, to HFCs, which are ozone friendly. So they were able to do all the things that those CFCs did for us, which we want, especially Floridians, air conditioning, refrigeration. So that's what CFCs were providing as a value. So HFCs still do that, but they do it in a way that's not harmful to the ozone layer. The biggest tragedy, though, is that HFCs are the most potent greenhouse gas that is accelerating the climate change problem as we fix the ozone problem. So that is now the focus of a lot of climate change regulation, is that, well, you fixed that, but you broke this even more in the process. So we're trying to regulate HFCs very aggressively and phase them out into some new alternative that is both ozone and climate friendly. The other difference between the two, though, is the political will part. And it might be hard to believe this, but the US was a leader in global environmental initiatives in the 1980s and 70s. And so the US was a big part of why we were able to get so much political will behind regulating stratospheric ozone depletion. The US is the biggest part of the problem why we're stalling on climate change. Totally different scenarios, because climate change is everywhere. It's produced in every sector of the economy, and the US sees it as a economic crisis waiting to happen if we're ambitious about fighting climate change. So those three factors, the politics, the economics, and the science. And also on the science for climate change, there was all that science I mentioned by the fossil fuel industry trying to confuse the public into whether climate change is really happening or not. So we certainly didn't have that with ozone either. So you have those three stark differences that have made climate change so much more challenging. And we really don't have much to learn from ozone because it's just so distinguishable.
Thank you very much. That was a very interesting answer.
Yeah, I did not realize that about HFCs. I knew that they were somewhat harmful. I didn't realize to what extent. So thank you for going into depth about that one.
200 times more potent than carbon dioxide.
Wow. So does anyone else have any final questions? It's 7:45, so I know this is time we usually end. So thank you so much for being here. If you have to leave, go ahead. Yeah. Anyone have any last minute questions? You can ask Dean Abate.
Yeah, any questions about law school or anything else about your pre-law experience gearing up for what's next?
If you don't want to ask out loud, you can always message in the chat, or you can message me privately and I won't read your name out loud. I know sometimes people are a little shy. Don't worry about that.
And you can email me.
Yes, your email is in the presentation, and I will make sure that Peyton has that for the minutes when we send that out. Real quick, Dean Abate, would you be okay with me sending out the presentation that you emailed me earlier, or would you prefer me not to do that?
No, that's fine. I'm happy to have you share that. And yeah, that works just fine. And also happy to have any kind of follow-up conversations with anybody about any of the topics or law school application process or
All
careers.
right. Well, great. Thank you. I'll make sure that's sent out as well. We can post that on the Facebook for everyone who's interested in reviewing that slide again, checking out his book, anything like that.
That sounds great. Thanks for hanging in there for a long session during finals. So appreciate your endurance and happy to continue the conversation in whatever way you'd like to.
Yeah, thank you. Thank you everyone for being here. If you're still on here, no need to stay on unless you have any questions or anything. That includes the directors. Also, feel free to stay on if you would like to talk, but other than that, you're free to go.
Thank you, Sydney. Thank you, Dean.
Welcome.
Cassie or Sophia, do you have any questions? I can't, Cassie, I can't tell if you're I can't tell if you're talking and if you're muted. She might have stepped back to take a minute. Well, I think that's everyone. Thank you again so much for being here. Let me stop.